Hello everyone, welcome to the legal world of Unacademy. I am Tanvi Singh, your Unacademy CLAT educator, and today we are going to learn about the legal jargons that we use in daily conversation. What is the meaning of these commonly used legal words and its relation with conviction? So, first of all, let me introduce myself. My name is Tanvi Singh. I have pursued my LLB from Symbiosis Law School, Pune. I have earlier worked with law firms and also I have worked in the legal publishing industry. I have been mentoring aspirants for law exams since last 5 years. So, let's start with our session. The first word is abandonment, giving up a legal right. So if a person has abandoned something, it means giving up. And the legal sense, it means giving up a legal right. Next, abduction. Abduction means taking someone away by force. Somebody has been abducted. So there the person has been moved. He has been taken away without the free consent of that person by force. Forcefully that person has been taken away. Next is ab initio. Ab initio is a Latin word and it means from the start of something, since the inception. It is commonly used as void ab initio in contracts. So void ab initio means that the agreement was void since the very beginning. It was not a valid agreement. And for example, a contract with minor is void ab initio. So it is void since the beginning, since the inception, from the start of something is ab initio. Next, absolute privilege. Absolute privilege is used as a defense in the cases of defamation under tort law. So absolute privilege means there are three circumstances in which if the statement from which the defamation arose was made in parliament, then there is absolute privilege about that. वो आपका defamation का tort नहीं होगा. If a person has been sued for defamation, then he can take the defense of absolute privilege. Similarly, in fair and accurate news reporting of court proceedings, there is also absolute privilege has been given to the defendant that it happened in such circumstance, fair or accurate news reporting हो रही है court proceedings की, that won't constitute as defamation. Similarly, the statements made during court proceedings, the two parties, while arguing about with respect to their party, with respect to the case, the matter in hand during a court proceeding, they are also being privileged. The conversation is considered to be privileged, and in that case also it will not constitute the tort of defamation. So this is a defense that is used in the case of defamation. Next, we come to abuse of process. So when criminal proceedings are brought against a person without there being any good reason and with malice, तो यहाँ पे कोई रीजन नहीं है, जबरदस्ती आपके criminal proceedings लाई गई है किसी के against, but there is ill intention involved. So there is an abuse of the process that the person has committed. Next, acquit and acquittal. Acquitting somebody means that when a court lets a person go without any penalty, no punishment has been given to him. If a court decides that a person is not guilty of a crime or the case has not been proved, it will acquit the person. Acquittal means the court's decision that a person is innocent of the crime they were charged with. Next is your ad hoc. Ad hoc means for a particular purpose. For example, a committee set up to deal with a particular situation is an ad hoc committee. In various cases, this happens. So, for example, some report has to be investigated in a particular case. Then a particular investigative ad hoc committee is, and the court directs to form this particular committee for the investigation of that report. So, for that committee's existence is till the time the purpose has been achieved. Ad hoc means that it is there for a temporary purpose, for a particular purpose, and it's temporary in nature. This is also a Latin word, ad hoc. So next is adjudge or adjudicate. It means giving an official judgment about something. For example, there is a person, he has defaulted on his debts. He cannot pay their debts. Then a court may adjudge him, give an official judgment that they are bankrupt. So this is what adjudging means. Next is affidavit. It's a very commonly used word. The affidavit is a sworn statement made by a party in writing in the presence of an oath commissioner or a notary public. So affidavits are used as evidence in the court proceedings. An affidavit in reply to a petition filed by a respondent is called a counter affidavit. So whenever a suit is filed, an affidavit has to be attached to it. It's a sworn statement made by the party. So the petitioner's response to a counter is called a rejoinder affidavit. Next, you have appeal. The appeal is a process by which the correctness of the decision of a lower court or tribunal is questioned in a higher court. So once a decision has been passed by a lower court, and you are not satisfied with that decision, it's against you. So you can approach the higher court in appeal. So it is a process by which the correctness of a decision of a lower court or tribunal is questioned in a higher court. Arbitration. Arbitration serves as a method for two parties to resolve a dispute through a private dispute resolution procedure instead of going to court. So arbitration there is an arbitrator who is responsible for hearing the claims of both the parties and eventually resolve the dispute between them. Next is bench. The composition of judges sitting to hear a matter in a court. In the high court, judges can sit singly, तो वो आपका single bench हो गया. In division benches of 2 judges or in full benches of 3 or more judges. In the Supreme Court, the vacation judge or judge in chambers may sit singly, single bench. Division benches comprise of 2 or 3 judges, and constitution benches 5 or more judges. This is very important, guys, because इस पे भी आपके questions आ सकते हैं. Cause list contains information like the bench, courtroom number, and the position of the matter. The registry issues cause list on the matters to be heard by the court on any day. Next is your contempt of court. A party willfully disobeying an order of a court can be held in contempt of that court. So if you are disobeying an order that has been passed against you, for example, an order has been passed directing you to do a certain act and you have not done it, so you will be held in contempt of court. And the law which is there is the statute is Contempt of Court Act 1971. This is defined as civil contempt. Any act that lowers the authority of the court or interferes with the course of justice is defined as criminal contempt. Each court has the power to punish anyone committing a contempt of the court. Next is issue notice. So when a court decides to consider a case, it asks the respondents to explain why the case should not be admitted. So एक show cause करना होता है. This is done by a notice sent to the respondents which give the details of the case and next date of hearing along with a copy of the petition. So if the respondent does not appear on this date, the court may proceed ex parte. So issue notice basically once a case has been put up. First hearing of the case, first hearing is basically for the court to decide whether this will be admitted or not. अगर admit हो गया, dismiss हो गया तो फिर तो कोई बात नहीं है. If it has been admitted, then issue notice होता है. Court passes an order as issue notice. So notice is sent to the respondents that this such and such case has been filed against you and you are required to appear on this particular date of hearing. And if respondent fails to appear on that date, the court may proceed ex parte. They give the judgment ex parte. Stay order. Stay order is also a very commonly used term. Legal journalism may be up day to day. You must be reading the articles wherein this act has been stayed by the court. There is a stay order passed in this case. The stay order is an application filed seeking an interim court order to prevent the respondents from performing an action or to prevent an order from being carried out. उस पे रोक लगा देना. So that is a stay order. And stay order की भी एक validity होती है. It depends on the judgment that has been passed by the court. The wordings of the judgment has to be considered. Sub judice. So a matter pending a decision by a court is called sub judice. Parties to such a matter should not do anything that would affect the outcome of the case. Very easy. Suo moto. So the court may take action on its own when facts requiring legal intervention reach its notice. Then the court is said to be suo motu. Next, Wakalatnama. Wakalatnama is the document by which an advocate is authorized to represent a party in court. So this is what Wakalatnama is. You have to attach the Wakalatnama with every petition, which will specify that that particular advocate, the lawyer who is pleading your case, is authorized to represent you in court. Writ and writ petition. So a writ is a direction that the court issues, which is to be obeyed by the authority or person to whom it is issued. A petition seeking issuance of a writ is a writ petition. That's it, guys. I hope you enjoyed this video. Kindly like, subscribe, and also you can refer to the description box for the link to my Telegram channel, for the link to my Unacademy classes, as well as you can use my referral code TanviS10 to avail additional 10% discount on the Unacademy subscriptions. Thank you so much.